Okay, so what we have in front of us is a case that basically was filed very, very quickly because of another case that was won on appeal earlier this year. So somebody saw an opportunity based on a case that they won and then decided to file a lawsuit. Basically, it's hard. It doesn't really make sense. If you look at the lawsuit itself, it makes zero sense. This is a lawsuit by probably around 30 of the biggest media companies in the country against a tiny ISP in Texas. Why are they suing that company? What's unique about it? Well, when you read through it, there's really nothing unique about it. Basically, this is a lawsuit claiming that this ISP has not terminated the internet access of people that use it and are also somehow downloading music or movies illegally through BitTorrent. Now, when you think about that issue, you would think that this issue should have gone away years ago, right? I mean, we've dealt with this kind of nonsense probably 10, 15 years ago. Why is it back? Well, because these media companies are not happy with the idea that it's so difficult for them to go after people that infringe, right? Obviously, if you download a movie, you download some music, you are liable for copyright infringement. But it's not easy to go after you. Why? Because you're one guy, and filing a lawsuit costs them a lot of money, and they have to keep all these law firms on retainer, constantly filing lawsuits. They'll try to threaten you into to some sort of resolution, but just like you, there is just tens of thousands of other people, and it's a pain, and it's expensive, and it's not very effective. Just finding out who you are is very, very difficult. So they changed their tactic. And in a lawsuit that I believe was filed in 2017 that was resolved on appeal, maybe I'm wrong, it was 2015 because it was an appeal in at the beginning of 2016. I think the appeal was filed in 2017, and it was resolved in February of this year. There was a decision in favor of these media companies, and that basically spurred them to file a new lawsuit which has very disturbing logic in it. And if they're successful again, basically will turn every ISP into Big Brother. They'll be required to watch what you're doing, and they would be required to actually terminate your access. People are complaining about people getting, removed off of Facebook, removed off of YouTube. Whether or not the unpersonalization or dispersonalization of individual off of social media and the kind of damage that can create. Think about a situation where, by law, your ISP would have to actually remove your entire access to the internet. No access to the internet whatsoever, because of allegation made by what the EFF, the Electronic Frontier Foundation, call a copyright troll. So let's go through very, very quickly just through the complaint that was originally filed earlier this year in April by these media companies. Then we'll go through the logic of some of the precedents of what they are basing this lawsuit on. And then we'll come back later on to discuss the response. But it's a disturbing, what do we call it, disturbing direction that these media companies are taking it, largely because they are deciding that it's too costly for them to sue people that are infringing. And as a result, can they instead go after the ISPs and prevent alleged infringers from ever gaining access to the internet? So let's put up the complaint first, right? And here we are, right? So this is the complaint, and you can see the various media companies that are part of this lawsuit against Grand Communication and Patriot Media Consulting. Patriot Media is really a consulting company, and they were removed from the lawsuit. This is only against Grand lawsuit, and it says here, plaintiffs are record companies that produce, manufacture, distribute, sell, and license the great majority of all legitimate commercial sound recording in this country. And this is basically the entire lawsuit in one paragraph. Defendants, here is which is the ISP. Defendants have been notified that their internet customers have engaged in more than 1 million infringements of copyrighted work over BitTorrent system, including tens of thousands of blatant infringement by repeat infringers of plaintiffs' copyrighted work. Despite their knowledge of repeat infringers, defendants have permitted repeat infringers to use the grant service to continue to infringe plaintiffs' copyrighted work without consequence. Upon information and belief, neither Grant nor its management company, Patriot, has taken any meaningful action to discourage this continuing theft, let alone suspend or terminate subscribers who repeatedly commit copyright infringement through its network as required by law. Upon information and belief, this is so even where defendants have specific and actual knowledge of those subscribers' blatant repeat infringement. Now, what's going on here? So first of all, the lawsuit is not technically by the media company. It's by another company called, I forgot the name here. This is Rights Corp. Is that right? Let me take a look because I wrote it down and I forgot, which is not good. Actual knowledge of those subscribers. Shouldn't put that on. I think it's called Rights Corp, which I will take a look later on to make sure that that was the name. But basically, Rights Corp is a copyright troll. At least that's what the EFF, the Electronic Frontier Foundation, calls them. They filed a lawsuit that came to a resolution earlier this year that basically said that another ISP should be held liable because they allowed infringers to go unpunished. Now, and then they used the win in that lawsuit to now extend it and basically try it out for a different reason. That was for a specific reason, and this is for a different reason. Now, what's happening here is that in, I think it's in 2015, if I pull up that original, where is it? That original lawsuit, which is BMG, and I believe we may have spoken about BMG earlier this year here. But again, this is a lawsuit that was really filed by Rights Corp, by this particular rights management company. But it says here, Cox is a conduit, which is basically an ISP providing approximately 4.5 million subscribers with high-speed internet access for a monthly fee. Some of Cox's subscribers shared and received copyrighted files, including music file, using a technology known as BitTorrent. As a conduit ISP, Cox only provides internet access to its subscriber. Cox does not create or sell software that operate using the BitTorrent protocol, store copyright infringing material on its own servers, or control what they do. So basically, Rights Corp, acting on behalf of music companies, sues an ISP, here Cox. They said, we've sent Cox millions of notices that people on their system are downloading music belonging to our client. Cox basically, after a while, ignores those notices. And what Cox says, well, it's because we have already blacklisted Rights Corp before that. Rights Corp, as a tactic, just spams us with millions of notices, which are completely unmanageable. And in each one of those notices, which they demanded we pass on to our customers, they basically threaten lawsuit and include basically a demand for money. You pay us, X number of dollars, we'll go away. Basically blackmailing customers. That was Cox's point. And they want us to suspend all those people, even though those people were alleged infringers, meaning this rights holder claims that they're infringers, but we have no basis to do it. So we did not actually suspend it. The court looks at it and says, well, under the DMCA, you're not liable for it, but you're required to have some sort of a reasonable process where you will block access by repeat infringers. But the law is not very specific of what it is. So whatever policy you came up with, we're going to accept. In this case, Cox had this 13-step kind of policy of how they're going to deal with repeat infringers. But when the court looked at how they actually implemented that, they saw through emails that employees in Cox never really implemented it, or it was haphazard. They implemented it here, but really reversed it there. Basically, there was an interest in generating profit, so Cox really never followed up on its own policy. The courts then found Cox to be liable, meaning what they did was insufficient, and so the DMCA did not cover them against the liability associated with their customers, and in the process created a very confusing precedent. Now, it's being, as far as I understand, it's being appealed right now. But earlier this year, we ended up with this very confusing precedent where Rights Corp won this appeal, right? So I'm assuming they're trying to appeal it to the Supreme Court. I haven't looked at the appeal format here, but maybe they're appealing it to the full courts of appeal with the full panel. But the idea sounds to, if you read what the court actually says, is you can follow whatever policy you have, but you actually have to implement your policy. You cannot just have pay lip service to the fact that you have some sort of an anti-repeat infringer policy, but not do anything about it. Rights Corp then takes that win and writes it completely differently and tries to, through this current lawsuit, expand on that original win. What they're saying here, because now they're suing this small ISP and they don't have any particular evidence against this ISP, it's a badly written complaint. The complaint never alleged any specific individual who actually infringed. They just says we have millions of notices. A notice is not a proof of infringement. They're not identifying any individual who infringed, not identifying any particular song that was downloaded. For that matter, all of the notices sent to Grand, this small ISP in Texas, all dealt with proof that, at least claims that things were uploaded to the server, but nothing that actually showed a sharing. So there's no actually true claim of infringement, because there is no claims of actually anything being shared, anything being downloaded, anything being sent through BitTorrent. What they're trying to do here is say that this other ISP is liable too. Why? Because we have proof that some of their subscribers have used BitTorrent. See, they took what the past precedent was earlier this year that said that Cox was liable because it failed to implement a policy that it already adopted, but just failed to follow up on it, and now says, well, any ISP that doesn't follow up on our notices, and again, they bombard this little ISP with millions of notices, just millions, just spamming them with notices. If they don't follow, they're liable for it, completely upending the entire DMCA process that keeps those internet access providers basically free from liability for the actions of their users here. And how do they justify it? By looking back at a series of laws that took place. First of all, we look back, if you remember, this goes back to, I believe, the 80s, the Sony, the whole issue of VCRs, right? Whether or not the VCR is illegal for if nothing else, because I don't have a copy of that, or a copy of that lawsuit, because people might use the VCR, what is today basically a DVD recorder, to record and then maybe share illegally movies or TV shows. And the court held that, well, the VCR is not a copyright infringing tool, because and they showed it through statistical work, that the prime motivator for people to buy the VCR is for time shifting. They can't watch something today, they want to watch it tomorrow. So they are allowed to take something and shift the time, and that's perfectly legal. That's fair use. Much more than that, the very fact that somebody may use what is otherwise a legally acquired product for illegal purposes does not make the entire product illegal, because it's predominantly marketed. Sony basically sold it for the purpose of actually I'll help people time shift. There was so much advertisement that they actually showed and introduced to the court that everything was intended being sold as time for time shifting. And when they did surveys, people were always talking about time shifting. Nobody told about, I want to record a show and then sell it to on the black market. That was not something people did. And so Sony is seen, has been misread to believe that as long as there is some substantial amount of legal usage for a device, it's not copyright infringement if somebody else uses it. That's not what it was. It was that it was substantially being used for lawful reasons, and it was marketed and used for that purposes. So later on, when the lawsuit with Cox against BMG took place, the issues there was, well, the argument was that by the ISP was that, well, our services is mainly used for lawful purposes, right? So just like Sony, we're just an ISP. The fact that somebody uses it for unlawful purposes does not create liability. Now, that is true. The problem was that the court then got into a whole discussion, which they shouldn't. Judges like to talk sometime. And rather than give a ruling, which was not necessarily incorrect, that would say that the ISP failed to follow on its own repeat infringer process, as a result, it's not a valid process. If you set one up, whatever it is, and you don't follow on it, you can then claim protection under that same process. They could have focused on that, and that'll be the end of it. But they started talking about this whole issue of whether or not they knew that people were infringing. Were they encouraging people to potentially infringe? Was it not exactly like Sony, but more like Grokster? If you remember, the Grokster lawsuit was different than Sony. In that case, people basically was file sharing, right? People were sharing music online, and they found that Grokster was a tool that was marketed specifically to allow people to infringe on copyright. That was really the purpose of the entire Grokster service. Person-to-person sharing illegally of copyright information. Yes, some people were using it completely legally, but it was marketed, it was pushed, it was acknowledged. People in Grokster knew that it was used primarily illegally, and statistical work showed that it was primarily used for illegal purposes. So when later on, when this rights holder sued the ISP, they were saying, what's happening here, the court started talking in this lawsuit about this issue, whether or not an ISP that allows the usage of BitTorrent is more like a Grokster or is it more like a Sony, and in the process confused the whole issue. And even though it ruled based on a very specific reason, such as that you had a policy and you didn't follow up on it, the discussion basically muddled up the whole issue and left us with a bad precedent. So this rights corp jumped on it, and within 2 months filed another lawsuit against, a tiny little ISP to basically try to expand on what is otherwise a confusing precedent, to say that ISPs, even one now where there's no proof that they failed to follow up on any sort of policy that they had, is now liable largely because this copyright troll claims through their spam of millions of notices and their threats of lawsuit and the demands that the ISP pass on, basically blackmails for settlements to customers, that would make an ISP liable, and in the process demand basically that ISPs now start policing all of you. Your ISP has to know everything, and any demand by anybody, including copyright trolls that just flood the market with allegations against any client, should be enough to shut off your entire access to the internet. This is where this lawsuit is. Basically, an absurd reading of a prior win that itself you hope would be reversed, but it's difficult. Whether or not the prior lawsuit will be reversed is difficult because the decision is not necessarily incorrect as much as there's so much bad discussion that is completely irrelevant by the judge in that matter. As a result, created confusion. So they are basically trying to force every ISP to scan, kind of like what Europe is trying to do with their law. This is a lawsuit that's trying to build on a prior decision, try to force every ISP to scan every single content that you're uploading and be able to be forced effectively to terminate your entire access to the internet based on either their automated scans or just blanket allegations made by by any rights holder with any claim whatsoever. That should be enough for them to terminate your access to the internet, or the ISP would be liable. Obviously, a terrible decision that would bring us closer to what some of the European laws are getting closer to.
When the lights are out and you stumble in the dark, you kept pushing on, but then you went too far. When your ship has sailed and all your dreams are lost, everything is wrong, you feel like it's your fault.